Good morning, friends. My today's topic is whether strikes by the advocate community is justified. Are there any exceptions where they can go on strike? So this is the issue I am going to discuss in this video, and it is very important issue. Be attentive, be settled. Now I am going to start my this topic. I may introduce myself. I am Ashok Arora, advocate, practicing at District Court, High Court, and as well as in the Honorable Supreme Court of India. So friends, in this video, I will discuss about important case law, that is ex-captain Harish Uppal versus Union of India and others. This case of ex-captain Harish Uppal versus Union of India and another adjudicated by the Honorable Supreme Court of India on 7th December 2002. It is a seminal case in the context of Indian legal system. This case addresses the critical issue of whether lawyers have the right to go on strike, balancing this against the fundamental right to speedy trial. The case stands out for its thorough examination of the roles and responsibility of the lawyers as officer of the court and impact of their action on the administration of justice. Friends, before proceeding further, let us dive into the facts of the case. The origin of the case lies in the experiences of ex-captain Harish Uppal, a retired army officer. He faced allegations of embezzlement during his tenure in Bangladesh in 1972, which led to his court-martial, subsequently imprisonment and dismissal from service. His attempts to seek legal redress were marred by significant delays and misplacement of documents, primarily due to the strike by lawyers. Aggrieved by these delays, Harish Uppal filed a writ petition in the Honorable Supreme Court challenging the legality of the lawyers' strikes. So, the primary issues examined in ex-captain Harish Uppal versus Union of India and another were, first one was whether lawyers have a constitutional right to strike under Article 19 subclause C of the Indian Constitution. Second issue was legality of the lawyers' strikes considering their impact on the administration of justice and client rights. Third one was the justification for a ban on large strike and balancing large interests with the legal system's functioning. And there was also definition of rarest cases where large strike might be permissible. And there was also discussion on the right to speedy trial under Article 21 of the Constitution of India. Now, the arguments were by the parties. And the petitioner, that was ex-captain Harish Uppal, he contended that liar strike are unlawful, disrupting the justice administration and jeopardizing clients' interests. Liars, as a court officers, have a duty to the smooth functioning of the judicial system. In this case, the respondents also included the Union of India, and they jointly argued that right to strike is the fundamental to the freedom of association under Article 19, subclause C of the Constitution. Now, the Honorable Supreme Court gave a reasoned judgment. The Honorable Supreme Court's ruling in ex-captain Harish Uppal versus Union of India was multifaceted. It firstly said no right to strike for lawyers. The court in ex-captain Harish Uppal versus Union of India categorically stated that lawyers do not have the right to strike or boycott courts. This was grounded in the understanding that lawyers, as officer of the court, have a pivotal role in the administration of justice. The judgment emphasized the unique role of lawyers in the legal system. It noted that strikes disrupt court proceedings and violate the right to speedy trial, thus impacting the justice delivery system adversely. The court suggested alternative means of protest for lawyers that do not disrupt court proceedings, such as they can press release and they can have peaceful demonstration. The decision in ex-captain Harish Uppal versus Union of India was based on interpretation of the role of lawyers as court officers, the right to speedy trial under Article 21, and reasonable restriction on right to Article 19. Now, coming to impact of the above case, the judgment had a profound impact on the legal profession in India. Firstly, it established a precedent that lawyers do not have a right to strike. It reinforced the duty of the lawyers to ensure the smooth functioning of the judiciary. Friends, this is such an important case that it is frequently cited in subsequent rulings related to lawyers' conduct and strikes. So, I am concluding my topic. In conclusion, it is a landmark judgment in the Indian legal framework. It effectively balances the rights and duties of the legal profession, emphasizing the paramount importance of maintaining the integrity and efficiency of the judicial process, while acknowledging the right of lawyers to voice their grievances. This judgment makes it clear that this should not come at the cost of justice delivery system. So this case serves as a cornerstone in understanding the professional ethics and responsibilities of the lawyers within the Indian legal system. That is all about my today's video and topic. I feel you might be enjoying my videos. If you feel that there needs to be little improvement, please feel free to guide me. That's all. God bless you all. See you again.